I want you to understand the roles that I play. Permanent secretaries are not necessarily accounting officers in some ministries. And the Secretary of Judiciary is a provision which is in the Administration of Judiciary Act. And therefore, I combined the three. There were only 4 thematic areas which judiciary was obliged to implement. The first one was to exploit processes for remote online adjudication of cases drawing from the COVID-19 lessons. The second one was to instill zero tolerance for corruption in the judicial system by introducing systems and periodic monitoring of judicial officers. And the third was to recruit more judicial and other officers to fill the established position in the judiciary. And the last one was to uphold the Administration of Judiciary Act 2020, which serves to provide for the efficient and effective administration of the judiciary, strengthen the independence of the judiciary, and provide retirement benefits for judicial officers and other related matters. Now, cumulatively, there have been progress on this manifesto implementation plan from 2021 to 2024. The first area of exploit processes for remote online adjudication of cases, the first one was to install video conferencing systems in courts. And for those who may not know, video conferencing system enables courts to hear cases online, and the suspect or convict doesn't have to come to court physically. Of course, this has got many advantages because the time it takes to bring the prisoners and the risks involved and the money involved is reduced by having these video conferencing facilities in the courts and prisons. As at the end of financial year 2020-2021, the judiciary had 5 courts with video conferencing systems installed. That was the Commercial Division of the High Court and the 4 High Court circuits of Mbarara, Arua, Masindi, and Masaka. What is the progress? In a bid to continue embracing online hearing of cases and learning from the effects of COVID-19, the judiciary has installed additional video conferencing systems, bringing a total now to 17. And these are the Supreme Court, the Court of Appeal, the High Court at Kampala, the Commercial Court and Criminal Division, 11 High Court circuits, Mbarara, Arua, Masindi, Masaka, Jinja, Soroti, Lira, Fort Portal, Kabare, Mubende, Mbale, Buganda Road, Chief Magistrate Court. Mr. Chairman, you can see that we have moved very, very fast. We are trying to see that we cover even the other courts in the next few years. Number 2 is the provision of computers and laptops to judicial officers as working tools. In the financial year 2021, the proportion of judicial officers with both computer desktops and laptops was only 52%. Now, the cumulative progress is that the effects of COVID-19 necessitate the judicial officers can work from anywhere in order to facilitate judicial officers to write judgments, computers, desktops, and laptops were provided. As at October last month, all officers, all judicial officers have computer, desktops, and laptops. So there is now improved performance as a result of having these tools. Provision of online legal reference materials. In the financial year 2020-21, access to online legal and research database for judicial officers, such as LexisNexis, was only 487. But as we talk today, in October 2024, access to online digital legal and research databases for judicial officers stands at 750. This is very, very big progress. What does this mean? It means that many judicial officers can access these materials online and make informed decisions. Expansion of the internet infrastructure in courts. As at October 2024, the average internet in courts across the country stands now at 46%. We need to make it even more as we receive funds. The second commitment was to instill zero tolerance for corruption in the judicial system by introducing systems and periodic monitoring of judicial officers. Chair, 4 approaches. The first one is to do with the Electronic Court Case Management Information System. What is ECMIS? ECMIS is an IT-based system that automates the entire process of a court case life cycle, right from the filing to the archival. The ECMIS was commissioned in 2021, and the ECMIS Go Live was launched on 1st March 2022. This ECMIS as a tool helps us to check corruption. Why? Because it minimizes human-to-human contact in the delivery of services and thus reduces incidences of corruption. A number of complaints had been registered of people who go to courts to file, and they find difficulties or they find inconveniences when some of the employees of judiciary ask them for chitu chidogo. Now we are trying to eliminate that one, so that even when you are in an aeroplane and there is Wi-Fi in the aeroplane traveling, you can file. Even if you are in your bedroom, you can file. In your sitting room, you can, even in a bar, you can file. So getting cases filed has been made easy, even more. So the average case completion rate has also increased at a rate of 17.5% in courts operating ECMIS. Interestingly, ECMIS has also increased non-tax revenue collections from 5 billion to 9.2 billion. That is very good money for the government. Other anti-corruption measures being implemented. Number 1, the development of the anti-corruption strategy to strengthen capacity to combat corruption is getting concluded. The judiciary has also provided uniforms to staff, specifically clerks, process servers, office attendants, drivers, to ease identification and thus reduce incidents of people masquerading as court staff. It's not unusual. It was not unusual to find some court clerks or other people in the court premises, some putting on suits and they pose as if they are the judicial officers, and they exploit the ignorance of the public and squeeze money from people. Now we have said no. If you go to a court, We should be able to know this is a driver, this is a process server, this is a court clerk, this is a magistrate, because we also intend to have all magistrates put on their attire when they go to court. And then the public will be, it will be easier for the public to identify who is who. We have also introduced actually a toll-free lines, which the public should use. And the media, please help me, help us. This number is 0800 111 900. 0800 225 587. Please report acts of corruption and unprofessional conduct by staff. Let's fight this war together. It's not just only judiciary. You are also part of the soldiers to fight this corruption. Now, the judiciary also installed CCTV cameras around the court premises, especially commercial court, division, Guru, Mbarara, Mbare, Fort Potro, Uganda Road, and as you get money, we shall have these CCTV cameras all over. The third commitment was to recruit more judicial and other officers to fill the established positions in the judiciary. We started with the recruitment of judicial and other officers as at 30th June 2021, as you see from the table. I'm not going to the table, you can see it. But we have progressed very, very well. Of course, we can do better. But if you look at the second table, you see that the approved position is 7,929. But we only have filled 31%. So from 2021 to 2024, the judiciary has received a total of 1,063 appointments and promotions, and they include Justice of the Supreme Court 3, Justice of the Court of Appeal 5, Justice of High Court 59, registrars 7, 50 deputy registrars, 23 assistant registrars, 122 chief magistrates, and grade 1 is 402, and administrative staff. I can assure you we could have done better.
Chair, for starters, I would like to say that one of the issues that has been an impediment for us in resolving land matters particularly has been the issue of pecuniary jurisdiction. This is particularly in view of the magistrates' courts, which are spread out across the country but have been having a limited jurisdiction. What do I mean by pecuniary? I mean the value of the subject matter. Chair, a chief magistrate in this country currently tries a land matter which is up to the value of 50 million shillings, and a grade 1 tries matters up to 20 million shillings. So knowing the value of land, if you scan through Kampala or metropolitan Kampala, you're not going to find many cases in this value because land has highly appreciated across this country. But this is something we are working on to ensure that the jurisdiction of the magistrates' court is enhanced, because for now, the highest caseload we have, or even the backlog, is in the High Court, where we have, out of our backlog of about 40,000 cases, about 26,000 is in the High Court. So if we resolve the issue of jurisdiction by way of amendment of the Magistrates Court Act, and if I sample for you just a few of we have 3 scenarios we are looking at. Either you enhance the jurisdiction of a chief magistrate to 200 million, or for a grade 1 to 100 million, or the other way around, you give a chief magistrate 100 million and you push a grade 1 to 50 million. The impact of the first scenario of 200 million would offload the High Court, according to our current statistics, of about 80%. And then if we go with 100 million, which seems to be a popular view among the stakeholders that we have consulted, you would be offloading the High Court of about 60%. Now, if you offloaded the High Court of the land matters, for example, land division now in Kampala has about 10,000 cases. If you offload and spread those cases around the magistrates' courts that are in Kampala, you will be quickening the resolution of land matters. And I wish to inform the country that the process of enhancing this jurisdiction by way of amendment of the Magistrates Court Act is on course. As of today, the Learned Attorney General is consulting the Chief Justice on the proposed amendment bill for the Magistrates Court Act. So when this happens, Chair, we shall be able to resolve the land matters quickly, and therefore even these cases of land grabbing will be completed in good time. But as we wait for that, the judiciary is not sitting. We are revamping alternative dispute resolution. Chair, the Honorable Chief Justice has commissioned a new set of court-accredited mediators who constitute, among others, the retired justices and judges and other judicial officers and other senior citizens of this country who are very respectable to handle many of these cases. These have been deployed in, among others, the land division. So once people are receptive to mediation, we will be able to see some of these cases resolved even faster. And mediation is a win-win, whereby this will help us address this perception of justice being only for the rich. Because in mediation, it's a level ground, and even the poor are able to negotiate and come out with something that is agreeable to them. So, Honorable Chair, this is something that is going across the country. We now have just finished a training of new mediators in Arua, in Soroti, in Fort Portal. So this is a journey that is continuing, and this is all intended at ensuring quick resolution of disputes, and land is a top priority on this matter. Chair, you raised an issue about corruption and the frustration of government projects. I wish to say that judiciary has deliberately ensured that we create as much awareness of our processes and our procedures to the people, to ensure that people are aware and come to the courts to enforce their rights. So we have done so many open days, court open days. We have done it at the regional levels, we've done it at district levels, we have even done a national court open day. All this is intended to create awareness, so that where somebody has a legal challenge, they are able to come for redress. And Chair, in these open days, it's not only the judiciary, all the different justice actors participate. So you find police is there to explain to the public their role. So if somebody was meant to receive PDM funds and they did not receive, they will know that they can file their complaint with the police. The prosecution is there, DPP is there to present and make the public understand. The court is there, the prisons are there, the civil societies, and even the legal aid service providers, they are there. And so we use these days to ensure that we send out as much information to unpack our processes and procedures, and this creates awareness and therefore reduces incidents of corruption. Chair, we do barazas, we have issued press releases explaining and written articles explaining court processes. For example, if somebody now is challenged in the area of bail to recover their money, the process is out there. We have displayed posters in the courts for people to understand the process. We have even simplified the receipt of refunds. For example, you can now receive money back through your mobile money number, which previously was a problem. There was a requirement for a bank account. So all these different areas which are prone to corruption, the judiciary is doing something, and there is some improvement. We are not yet there, and we are not going to say that judiciary is clean. We still have incidents of corruption. We have some of our own officers undergoing trials for corruption-related offenses. Chair, we have officers, both judicial and non-judicial, on interdiction because of corruption-related matters. So a lot of work is still going on here, and that's why we have an improved inspectorate of courts that goes across the country, both on ad hoc and scheduled inspections to ensure that we address corruption at all levels. Lastly, Chair, on this matter, the Anti-Corruption Division of the High Court is still working. And I believe if we scaled the success of the fight against corruption before that court and now, Chair, I think all Ugandans will agree that we have made some progress. I think some of the big names in the fight against corruption have been convicted through this court. So the court continues to work. Those who are charged still continue to go there. And the court continues to hold sessions across the country. Just like last quarter, they were in Abim, they go to the west, they go all over the country handling these matters. Chair, you raised an issue of backlog, and somebody else also did the same. I wish to state that, yes, we have made some improvement. It's an issue where we are continuing working. We have a 2017 case backlog strategy. Chair, that strategy pointed out 3 main issues that were causing backlog. One of them was the people, and the people cuts across right from staffing to the advocates to the public, the different roles that people play in the justice process. And the PS, in his response, he has given some of the solutions that have already been provided, like that enhanced recruitment so that there are more judicial officers available to be able to handle matters of the public that comes to court. In terms of the people, there were issues of attitude. This is why we are doing a lot of sensitization for people to understand what we do and also be part of the process in ensuring that they perform their role. Because, Chair, we don't operate in isolation. We depend on, for example, witnesses who come. So even the public has a role to ensure that we perform our role. When you produce those witnesses, when you're summoned, that you are contributing to our output. So that strategy is under review, and once the final document is out, certainly it will be shared. But in the draft, we have really performed well in terms of our efforts to reduce backlog. Chair, also there was an issue of laws. Some laws were found to be complicated. And Chair, that's why we have a Judiciary Law Reform Committee that is time and again coming up with different reforms to simplify laws and make access to justice as simple for people as possible. The other challenge in that strategy that was identified was infrastructure, and PS has really submitted on this, that we are not there, but we are somewhere in improving infrastructure and sending out our courts as far as we can go, even with a plan to decentralize the Court of Appeal to ensure that even access to justice at that level is improved. Chair, as a comment on military courts, there were 2 concerns, just to say that the sub judice rule does not allow us to discuss matters in court, and so the encouragement is that let us wait for the decision of the Supreme Court. It will certainly come out, and it will guide the nation on this matter.